Alrighty, guys. Uh, Thank you for joining us on this lovely day. We are starting our IP focused webinar, our IP at Lunch, a 10-session micro webinar series for entrepreneurs, creators, and small businesses. My name is James Greenwood. I am here at Greenwood Law. I am an attorney. I'm licensed in Iowa and Illinois. With us today, Phil Schaefer. And Phil is having some minor technical difficulties, so I'm going to go ahead and start us off. My background is essentially in business law and estate planning. I will also have a tax law background. So when we are talking about estate planning, business law, or IP, I have a pretty good handle on the basics. Phil is our new of counsel, and he is a little more focused on that. So to give you guys a little bit of background on Phil, Phil is a graduate of Drake University Law School. He has his doctorate of pharmacy as well as a Juris Doctorate degree. He is a proficient business and IP attorney. And while he is focused primarily on patent and trademarks and copyright, he also does provide some great work in the business space as well. So, Phil, thank you for joining us. And while you are getting that sorted out, I will go ahead and get started. So today's focus is IP 101. What exactly is IP? That's the core question that we're going to try to talk about. And what do people need? I have some talking points that we can definitely get addressed and start down that path. As far as best practices and how do we, kind of think about this, as a general rule, let's start with the basics. My name is James Greenwood. I'm an attorney licensed in Iowa and Illinois. If you're joining us afterwards, just a quick reminder, this is not legal advice. You should not take this as legal advice. You should definitely get your own attorney if you have specific questions about any specific issue that you have. You should always seek an attorney anytime you have any of those questions. So with that in mind, let's talk about what is IP, intellectual property. So intellectual property generally refers to protection of assets of the mind, right? So things like inventions, brand names, logos, written works, music, designs, and trade secrets. And so this is kind of a broad field. It's the idea that we should protect the rights of the creators of things, the people who produce things for our country, our economy, people who come up with a better way of doing things. And if you've ever been through the patent archives, you'll see that there are some absolutely wild patent applications out there. I've seen everything from, people patenting a firearm-based mousetrap to, I think I've seen one where I've actually seen the patent for toilet paper at one point or another. I think that did come through. So IP is this cornerstone of all of our modern business. It's really enabled our creators and companies to safeguard and protect their assets and monetize those assets, which then in turn allows them to pay for ongoing research development and better make sure that they're able to capture the value of their time that they've spent in the creation of that asset. And so why does it matter? IP really protects your competitive edge and reputation. and it enables you to control how your ideas or products or brand are used. People don't appreciate it. So most creators don't appreciate if somebody takes their thing that they've gone through this huge production process to create, either a brand or a item of property or something else, and they just run off with it. My clients never appreciated that. And so we've taken great pains over the years to send demand letters where appropriate to people to, hey, you need to stop doing this and pretending to be me, right? Or we've had a couple of people who had employees, and maybe those employees had uh, very relevant um, information. And we wanted to say, hey, look, you're not allowed to use this for the benefit of a subsequent employer. We spent a lot of time building this thing. And so with those types of information is incredibly valuable, and they can be the most valuable assets in your business. But you have to enforce them. So with that said, IP can be a valuable business asset. It can be licensed, which means that you're allowing somebody to use some portion of that asset. It can be sold. Sometimes, depending on the value of the asset, it can be used as collateral in a loan. A great example is Ford once used their Blue Oval as a as actual collateral in a loan deal, which I had never heard of, until then, and that was a long time ago now. But it was certainly something that it was the first time I saw it. It surprised me. So let's talk about the four kinds of IP rights, and we talked about these very briefly in passing before. The first type is trademarks. The second one is copyrights. The third, patents, and the last real category is going to be your trade secrets. So your trademarks are really common. We see these everywhere. Every major brand has trademarked their particular brand. And so when you've got a trademark, that's something that protects a name, a logo, a slogan, or some specific brand identifier. Um, and with copyrights, we have original works of authorship. So that would be like your book, your next great American novel. You've got it could be a piece of art that you've created. It could be a piece of music that you've written or even performed potentially. Software potentially again. And it could be even more, right? So use for creative content, um, on things like websites or marketing materials, media, and there are some pretty hard limits, but we're not going to get into the hard limits on where those copy or what becomes copyrightable and what is not, today. But we will definitely, get into that later on a little bit in this series. Patents. Anybody who's watched late night TV has seen one of these patent commercials. Protect the thing you've invented, right? So it protects inventions, processes, or new technologies. And so, um, the real thing that you have to keep in mind for a patent is something has to be novel and useful. That's kind of the key pieces, but there's more than that, and there are multiple things that go into that. But that's the high level. If it's not novel and it's not useful, and generally it's got to be a product or a machine or some sort of process or something, right? And it's got to be patentable material. And again, we're not getting into the deep portions of this today. We're just going over the highlights. Last, trade secrets. In trade secrets, maybe you've chosen not to patent something. Maybe it's not patentable. Um, Confidential business information, recipes, formulas, processes. Sometimes these things are not patentable. Sometimes they're not copyrightable. Sometimes they're not trademarkable. But this trade secret, this thing that makes your company go every day, right? The trade secret piece is incredibly important. And when we have those trade secrets, those trade secrets are potentially very, very valuable and potentially um, um, so those trade
Yeah.
secrets, and I'll just finish up where I'm at. Trade secrets here, we're talking about that confidential business information that from day to day makes sure that you are able to protect the things that make your business go, but maybe not copyrightable, trademarkable, or patentable. And even if it is one of those three things, maybe you've made a strategic decision not to um, make a formal copyright, trademark, or patent on it. So um, I've kind of gone over just broadly, Phil, these types of IP rights. Is there anything that you can tell me, that I kind of missed, or we're kind of getting into this, big picture, right? How do is there anything I missed that you want to talk about there?
Yeah, I guess just the practical nature of making sure you have these rights and then asserting them, I think is important for the creator, whether you might be an inventor, artist, or business owner. Um, so some of these they exist merely because you made them. So one of them is or the example with that is a copyright is once you create that work of authorship, it it's copyrighted. It's just not registered, and so there's a cost associated with registration of copyrights and trademarks, and then certainly patent applications that individuals and entities need to be aware of. So that kind of goes back to what you mentioned about strategy. Is oftentimes uh, the cost is something to consider in maintaining
So
the rights of each one of these.
So how, I mean, let's talk about how to decide which IP rights somebody needs. I mean, what's the question? Let's just start with what are the questions that you ask to decide which IP rights you might and might have. Let's start with the questions asked
Yeah.
with the what IP rights do I have? Let's start with that.
Yeah. And I mean, just full, like to begin with, if you're operating in commerce, you likely have some form of intellectual property, whether you realize it or not. So, the way to approach that is start with the simple question of asking yourself, what am I looking to protect? And just nothing like just start there. Is it a thing? Is it an idea? Is it a representation? And that kind of guides you to the next step. Um, and if you're talking about some sort of innovation, um, oftentimes that's where you're going into either trade secrets or patents, and some sort of improvement that gives a competitive edge over a competitor in the same area of commerce is going to be um, one of those that kind of implicates the strategy of how you want to um, apply that right. And then in terms of how you distinguish yourself from your competitors, oftentimes that will be your trademark or service mark if you're providing a service. So when you're thinking, how do I keep my customers from getting confused with what I'm doing? Oftentimes that means you're in trademark territory. Um, and then and anything that you have a creative expression over, and it even though it might not sound very creative, like a business report or an architectural plan, something that has um, uh, pen to paper in tangible form, some sort of medium, and it doesn't have to be pen to paper, but um, an idea worth or an expression worth protecting. That's when you're in copyright territory. Um,
Uh,
so it gets it. To be honest, that sounds like a very simple question, and there's general definitions of each type of right, but they are intertwined very much so in practice, to the point that once you get to the point where you want to assert a right or obtain that right altogether, that's when you're going to want to consult with your attorney, which at Greenwood Law, we have the means to do so, and we're here for that. So I know that doesn't directly answer the entirety of the question, but that's about as best as I can outline it.
Outstanding. Yeah. And, let's talk about, the pitfalls, right? And I'm going to go through these kind of one by one. We had talked about these at one point or another, but one of the things that we talked about was, what happens if you sit on your rights and you decide, not what's the consequence, um, of not filing for a federal copyright, trademark, or patent?
Yeah. Well, you could, I mean, you could lose the exclusive ability to perform that activity or to distribute, to represent that intellectual property altogether. And so the consequence of that is essentially you lose your whatever competitive edge you might have over excluding others from using, making, selling, posting, reproducing, distributing. You lose that, or it's very very possible, and the ways in which you can do so for each is numerous. And then you could be out the economic benefit of that right if you're not mindful of what you have and what it takes to maintain that right.
And let's say that you do actually, um, register something. Um, you know, is the registration, does it give you any advantages? I mean, versus having a unregistered, the thing that everybody thinks about, right, is the patent world. But let's say that you've got a registered trademark. I mean, and somebody else comes in and you've got that thing registered. Does that give you any extra rights?
It I Yeah, so it does in a it does. Um, with trademarks specifically, uh, once you start using the distinguishing mark, um, even though it may not be registered, it is still yours, and you do have a right to it. However, when you register that trademark, you're given a federal preemption of use of that mark, even in geographic areas throughout the nation where you might not be engaged in commercial activity. So that's one huge benefit to federal registration. And then the other is that it puts your competitors on notice as to what that right is, and it has a general deterrent characteristic of it, because of that. So it kind of bolsters what you already have in that it puts it out there as marking your territory of what you have, and are able to use.
Absolutely. All right, and let's ask some questions about, is IP protection automatic? I mean, and a great example of this would be for patents. Do I automatically get a protection for my patents if I don't file those?
That's a great question. And Thomas Edison, he's famously quoted, or his famous quote along those lines is that a patent is a ticket to a lawsuit. So, um, although you may have a registered patent that's been maintained and is active, that doesn't necessarily mean that the the patent office is going to take it upon itself to ensure that you maintain those rights, it's incumbent upon the owner of that patent or whoever has rights to assert them themselves. And what the patent registration will do is to delineate what that right is and what the scope of it is, so that you can proceed with enforcing that, whether it's through litigation or other means.
Yeah, absolutely. And I think one of the things that I think over the years my clients have always been shocked when somebody infringed on their rights, or maybe they infringed on somebody else's rights, and they got that dreaded cease and desist letter. And I will say, from the strengthening of rights position, the infringement of these IP rights, generally puts our clients in a really solid position if they've got that registration done, because it provides a more clear path to attorney's fees if they're victorious in the courtroom. So it takes away some of the potential disincentive, um, for them to enforce their rights, and it incentivizes the infringing party, um, to maybe not, maybe they to think about carefully what their potential risk looks like, because it reprices the entire process. So it's certainly
Absolutely.
it's
And
certainly something to think about. So let's talk about um, a couple of.
and James too. I was just going to add to that, and we're talking in terms of um, actually using that property for its intended purpose of economic benefit too. But another area that registration serves, and making sure that you have everything in line with that, would be for your business valuation. That comes in very handy when you're trying to put a number on, like a value on something that's intangible. Just something to consider too, even if you're not actively using your intellectual property, that it will still help with valuation to have registered.
So I mean, let's talk about folks who have really really strong rights established, for a second, and give some real world examples here. Let's start with a trademark. Two things come to mind when we're talking about incredibly powerful trademarks. Um, Three things really. The first thing that I always think about when I think of a trademark is, you know, if I say the words golden arches, I mean, almost everybody, I think, possibly, potentially in the world, might think of McDonald's. It is an incredibly powerful trademark. I think that they've made a number of pieces of case law around that trademark, and it is a mind-bendingly strong trademark. I mean, they own that trademark, and even if you even get close to that, I think there's a pretty good chance that a court would go to squash that. But let me ask, can you trademark a color?
Well, that's funny you mentioned that. That's exactly the example I wanted to jump to next. Is you absolutely can. So the most famous example of that in my opinion is Tiffany blue. So thinking jewelry, the certain specific blue hue that the Tiffany and Company uses is trademarked, and that allows them to market their materials exclusively with that color, and their competitors are not allowed to do so in that area of commerce. Now, something just to highlight where intellectual property can get weird is, you might think, okay, well, they have their own color trademarked, but if I wanted to start selling tractor implements in that blue color, that would likely be okay because it's not operating in the same area of commerce as Tiffany, which is making fine jewelry. And the likelihood of confusing consumers probably isn't very high. So I just wanted to use that as an example to highlight how nuanced some of this stuff can get. And when you're evaluating your own business activities, whether to gain the competitive edge or just to make sure that you're not exposing yourself to too much risk, those are the sorts of questions you may want to be asking your attorney and get clear answers on, or as clear as possible answers on.
Yeah. And we could go on. I took an entire class on trademarks, copyrights, and patents in law school. And ever since then, I've dealt, tangentially with these things. And I could go on, we could spend, literally hours, which is what we're going to do over the course of the next 5 weeks or so, talking about all of these different things. I did want to hit something that's not typically addressed, trade secrets. I think the one that springs to mind for me, and I think that most people can, really relate to, the formula for Coke. I mean, that's as
Yeah,
secret as it gets, right? That's like state level stuff right
that's
there.
right. Yeah, that's right. And yeah, it's good stuff too. And so, yeah, trade secrets are options. Perhaps because they're not registered and they don't necessarily there's not a separate and distinct trade secret office at the federal level. I don't know. But oftentimes it's just for the general public, largely unaware that having protected confidential information or a method or a process is maybe your best bet in ensuring a commercial advantage over competition. So, Coke, yeah, the Coke recipe being probably the best example of that. The other one that comes off the top of my head is the KFC spice recipe. I've enjoyed that, whatever that is. I've enjoyed it myself. But that's exactly right. What you mentioned before is there may be a strategy implication to choosing a trade secret over a patent. So if you have something that um, you can do so in perpetuity, whereas a patent term is only 20 years from the date of filing. And so that might be something that you're weighing out. The other thing that you might be weighing out is whatever the risk of, if you were to pursue patent protection, the risk of after it's granted. That might be something you're wishing to avoid, or whether
Bill, you broke up there for a second. The risk of what after you file the patent?
invalidation.
Oh, okay. All right. Got it.
So yeah, and that's just an example of some of the considerations in making of choosing to keep something secret versus putting it in the public domain, which is what a patent does.
Okay, great. All right. So we're just about out of time here. The next steps, for folks, really is, people need to make sure if they're thinking about IP, make sure you identify key ideas, products, or brand assets that really drive your business, right? And start there. The second thing, map out which IP rights apply. Third, you got to take action to register, document, or somehow some other way protect your IP. And fourth, connect with an attorney. I think, and that's I think the most important thing you can do is connect with an attorney, figure out what your rights are and how to protect those rights, because IP, this intellectual property, is what drives everything. Again, my name is James Greenwood. With me, I have Phil Schaefer. Phil's an attorney licensed in Illinois. I'm an attorney licensed in Iowa and Illinois. Phil is also licensed as it's a patent attorney before the patent bar. Is that correct, Phil?
Yeah, yep. Registration number 8903. So you can find me on the USPTO website.
Thank you for joining us today. And if you're watching, this is where we're going to cut it off. For the people in attendance, we are going to go ahead and open up Q&A. If there's anybody who has a question, you can go ahead and raise your hand. Otherwise, we'll wait just a minute to see if any of those hands get raised. If not, we're going to go ahead and cut things off here. Seeing none. All right. Thank you for joining us, and we hope that you have a wonderful day. We'll look forward to seeing you on Wednesday. Thanks so much. Goodbye.
Thank you.